and it's a good section. Go ahead. All right. A very warm welcome to everyone participating today. I'm happy to invite you all on behalf of Team CNICA. The CNICA is a renowned arbitration institution that was established in the year 2001 in Chennai, India. We also have a mediation center and host study series every month as part of ECHR resources. The session that we are actually conducting today is part of the study series. Well, so let me introduce myself. I'm Harshita. I'm an attorney and international arbitrator and the founder of the law firm Let's I reside in Michigan, United States. And today I'm hosting this session in the capacity as Chair International Arbitration of CNICA. Now, the reason that we chose the topic sports arbitration is because it is a developing branch in the ADR system. Also, there are different sports arbitral bodies in different federations that are set. There is the CAS, which is the Code of Arbitration for Sports. It is supposedly identified as the apex body for sports arbitration. So the CIS was set up in Switzerland in the year 1983. It is pertinent to note that the CAS was established by the International Olympic Committee. So today we have with us Dr. Valani, an eminent sports arbitrator, who is going to share with us his overview on international sports arbitration. Also, we have Dr. Chong, a Chinese lawyer and arbitrator, who's going to discuss with us a very interesting case study on anti-doping. So let me introduce our first speaker, Dr. Valani. He is a very experienced litigator in both international and domestic cases in the Swiss Federal Supreme Court. He has been a partner at the law offices at Zurich since 2005. His area of expertise is commercial, employment, entertainment, and aviation. He has also published books on litigation and sports law in Switzerland and has lectured widely. Welcome, Dr. Valani. Please take over.
Thank you very much. Welcome to everybody, and thank you for the invitation to speak to you. I will now share the meeting. Let's see, like that. This one. Huh? Do you see?
Yes, we do.
Okay, very good. So I start to give you an overview in international sport arbitration. And that is something you can look afterwards, what I was already presented. I think I have to start first with the pyramidal structure of sports organization. Then I will talk a little bit of settlement of sports related disputes. Then it is important to speak also about the internal courts of sports organizations, and then sport arbitration, the Court of Arbitration for Sport, and appeal possibilities of decisions of the Court of Arbitration for Sport to the Swiss Federal Supreme Court, and how you can appeal a Swiss Federal Supreme Court decision to the European Court of Human Rights. That is a little bit what I will try to present you. I will not always follow what I have written. You can read it perhaps later on when you receive the PowerPoint presentation. Okay, let's start to a little bit describe how sport is organized in the world normally. Let's forget America, because it's a total different system in America. But Europe and other nations, also in Asia, this is the structure. you have in every sport normally an international federation, and only one. This is this one principle of this situation where you have a pyramidal structure, on top the international federation, then the members, which are the national federations. And you can see, I have taken an example from football here, and you can see the clubs below, and the members of the clubs are the athletes. So you see the athletes, they are all indirect members of the, or they are direct members of the club and indirect member of national federation and international federation. Why is this important? Because this is the top-down approach. So if you want to rule sport as an international federation, you put in place rules. And if you want to harmonize the sport all over the globe, then you have to force the national federation to accept your rules. And the national federation has to force the club to accept the rules. And the club has to force the athlete to accept the rules. That is what is in sport always the case. So that is also how they bring into place that you have to accept arbitration. We will come back to that later on. Okay, then it is clear that any federation and any association needs certain power, and also, most importantly, the disciplinary power. That is also where they base their decisions on, the power to decide on their own statutes and regulations. Then, where do these international sport organizations or national sport organizations take the power to make their own rules? And it's clear that it depends on the national law. Now, as you all know, a lot of international federations and like IOC, FIFA, UEFA, they do have their seat in Switzerland. You may wonder why. Well, one big reason is that Swiss law does give them a lot of autonomy, a lot of freedom. So if you compare the Swiss law with, for example, the French law, in Switzerland, the state does not interfere into any affairs of a federation. Whereas in France or Italy, the state has special rules to exercise a certain control on federations. And that is what the federations don't like. That is the reason why they want to come to Switzerland, because here they have a lot of freedom to do what they want. Then we have here the right also of this sport organization to have internal bodies who decides on the applications of their own rules. So these are not arbitration bodies. These are internal decision making power of an association. It's like any decision of an association is a decision of an association and not an arbitration decision. So, but they have the right to pronounce sanctions, to ban a player for doping or for whatever reason. And of course, they are not outside of the law. The law is the law, also for the sports organization. So there are also limits in Switzerland. So they must comply to state law where it is, and general legal principles like the right of a fair hearing, right to be heard, all these things they must, of course, respect. Also when they make a decision in the association. Now, a lot of international federations therefore have their own courts, but not arbitration. I told you it's still an association decision. Let's, for example, take FIFA. They have a disciplinary committee, they have an appeal committee, they have an ethics committee. They have rules. They set rules. They are free to set up rules for these committees. They put in place persons to decide, and they make a decision. That is all guaranteed by Swiss law. They can do that. That's not a problem. Then what is important, also continental associations can do the same, national federations can do the same, and they all do the same. They all issue decisions that later on can be appealed. And then it depends where it goes, and we will come to that later on. Now, that is what I told you. This is very important. We have now these internal decisions of the federations, and you normally are not happy with these decisions always. So you try to bring these decisions to another instance outside of the federation. Perhaps you think that, well, it was a decision of the federation, it's not so neutral perhaps. Let's go to a more neutral place to control them. And that is what you can do. You, when you want to do, the first thing you have to make is you have to exercise all possible remedies within the federation before you can appeal to another instance. That is very important, because if FIFA, for example, has an appeal instance after its first instance, then you cannot directly go outside with the first instance decision. You must appeal first. Otherwise, the other court will not enter your case because you have not exercised all possible remedies in the association. Now, if you have such a decision of a sport association, that is final, where it's no other possibility in the association, then you have the choice to go to a state court or to go to a court of arbitration. Whether you can go, it depends on the state where the association has its seat. For example, for all associations having its seat in Switzerland, you could bring every decision of an association to a state court. That is a fundamental right of every member and every indirect member to appeal. And what you can bring to the state court is that they violated the statutes or regulations. That is something you can bring. However, if there is an arbitration clause, you cannot go to the state court. Well, you can go, but the state court will say, yeah, we are not competent because there is an arbitration clause. Okay, so now, what would be the advantage of sport arbitration. You all know arbitration is different than normal court. It is perhaps less formal, and it is perhaps quicker, simpler, perhaps more flexible. And in sports, it is especially important to harmonize the interpretation of the sport rules. And this is the reason why it makes sense to have one court deciding the sport's decision of a certain sport. It must not be the Court of Arbitration for Sport. It can be another arbitration court, but it does make sense for a harmonized interpretation of the rules. Then you normally in an arbitration court have specialized judges with special skills also in sports laws. Of course, what you need to be able to go to an arbitration, as you know, you always need an arbitration clause. In sport, it is quite different than in normal or commercial arbitration. Yes, of course, you can have an arbitration clause in a contract. That is possible. But in sport, these arbitration clauses are normally integrated into the statutes of the federation. And as I told you, the paramedical structure, the International Federation says which arbitration system you have to look at and which is imperative, mandatory. And then it goes down to the national federation, then to the club, and then to the players. That is the way they all bind the players to this arbitration. And as you can see, it is, of course, not the same as commercial arbitration, because commercial arbitration is all by free will. Two parties agree to go to arbitration. In sport, it's totally different. We cannot talk about free will. We have to talk about forced arbitration. The athletes and even the national federations are forced to accept these arbitration clauses. And that is very important. We come back to that later on. Now, who had the idea to bring and set up an arbitration in sport? It was IOC. As you know, IOC has its seat also in Switzerland. And it was back in 1983 where the president of the IOC was Juan Antonio Samaranch. He had the very good idea to, he was thinking, we need somebody who decides every cases in relation to the Olympic Games in a harmonized way. Because before that, the Olympic Games were in different countries, and without this Court of Arbitration clause, in every place where the Olympic Games were held, you could go to the court to try to sue them, to find out. Yeah, you can go around to shop where the best law is to sue the IOC. And that is the reason why they tried to implement the Court of Arbitration for Sport. And as it is, Swiss law was very good for any association because it gives freedom. Switzerland is also known for a very, let's say, liberal arbitration-friendly law. And it is the Chapter 12 of the Swiss International Private Law Act, which gives a lot of power to any arbitration, not only to sports arbitration, but to all other arbitration that have its place in Switzerland, its seat, because it's very, very, very open. And as you will see later on, Swiss law does give the arbitrators a lot of power, because you can appeal a decision of an arbitration court with a seat in Switzerland, be it the COS arbitration decision or any other decision of an arbitration body, but the line to appeal is so fine that it is very, very difficult to win. It is extremely difficult. So the chances are perhaps less than 5% that you can win an arbitration appeal against in the Swiss Federal Supreme Court. And that shows that the power of the arbitrators in Switzerland is extremely big. And that is one of the reasons why in commercial arbitration, they come to Switzerland, because if a decision of an arbitration panel is done, then you can be quite sure it is over. Okay, they can appeal, but the chances are very low. So it gives a certainty that the arbitration decision is respected. Okay, then what did Juan Antonio Samaranch do? He introduced in the statutes of the Olympic Charter a provision that all participants of the Olympic Games and every case in connection with the Olympic Games, you can go to the Court of Arbitration for Sport. That was his idea. And IOC, as the founder of COS, they decided everything. They decided in the beginning, they decided who can be a judge, what are the rules. So you can imagine that this is a little bit a problem, a conflict of interest, that you put in place a court who decides about your cases and you decide everything. So that is the reason why after 10 years, it took 10 years, that one rider, a Swiss rider, took a case to the Swiss Federal Supreme Court to test whether the system is okay. She lost the case because IOC was not a party of that procedure. But the Swiss Federal Supreme Court decided that the system put in place by IOC was not independent enough in case IOC would be a party. Okay, so that's the reason why in 1994 IOC had to reform COS. They did it by putting in place a foundation. It is called ICAS. It is ICAS now that is ruling the Court of Arbitration for Sport. They decide now everything. They put in place the arbitrators, they put in place the system, and you can see the composition of this ICAS, where you can see that the athletes are not so well represented. They have only 4 places in ICAS, whereas federations and international organizations in sport have 16 places. And these 16 places, they elect the 4 members of athletes. So it's not a very perfect system actually. But as you know, the ICAS is like ICC. They also put in place the rules, and ICAS puts in place the rules of the Court of Arbitration for Sport. So they adopt the CAS code, they elect the president of the Court of Arbitration for Sport, they elect the president of the ordinary arbitration division, of the appeals division, and so on. And they decide also if you, in an arbitration case before CAS, to challenge an arbitrator. You can challenge an arbitrator, but then it's not CAS who decides, but ICAS. These are two different bodies. CAS is the panel, the arbitration panel, and ICAS is the, let's say, the organization panel. Huh? Okay, now the CAS code is the let's say the Bible of the Court of Arbitration for Sport. If you want to know how a procedure works, you go into the CAS code. Huh? And you can also go to CAS for mediation. You can go for normal arbitration and for appeal procedure. So that is what CAS provides. They also give legal opinions to international sport federations. And they have newly formed also a CAS anti-doping division. This was done for federations, national federations who do not have enough power to put in place a very sophisticated doping panel. So these national federations can opt for a CAS anti-doping division, which will be then first instance, and a decision of the CAS anti-doping division, you can appeal to CAS. That's very new. For 1 year ago, they were doing. What CAS is also doing, they put in place ad hoc divisions. That means they put in place special rules for special games, like the Olympic Games, FIFA World Cup, UEFA World European Championship. What is the idea behind ad hoc divisions? The idea behind is that you have arbitrators on the spot, because on the Olympic Games, you have to decide within 24 hours or 48 hours, because the next race comes and you have to know whether a person is disqualified or not, whether a certain result has to be annulled or not. That is the reason why they put special rules for these special games. Now, also important is, as we were saying in sports arbitration, here is a closed list. If you have to select an arbitrator from this closed list. And as I told you, only ICAS decides who is on the list, and you have to be a person, a lawyer, of course, with a sport background, sport law background. So you can be quite sure that you get a person with a qualification in sports law. Okay, now what does CAS decide, the Court of Arbitration for Sport? As in commercial arbitration, if two parties make, for example, a marketing agreement, they can put in place as arbitration clause, the ordinary arbitration or mediation clause from CAS. Okay? That means if a dispute arises out of such a contract, you can go to CAS directly. Like ICC, that's the same. But the important thing is not this clause, but important is the appeals panel of the Court of Arbitration for Sport. And when are they competent? As I told you, IOC, but also FIFA and all big federations put an arbitration clause into their statutes. And this clause means and says that if a final decision of a federation is given, you have mandatorily go to CAS for appeal. That is where the most cases come from CAS. They are not ordinary arbitration. That is a very, very small amount of cases. The big amount of cases are appeals. So you have already a decision of an association and you appeal this decision to the Court of Arbitration for Sport. That is what is important in CAS. Now, if you go to CAS, you have to tell them that they are competent. You have to show them. So first, in ordinary arbitration, you have to tell them, look, this is the contract with the arbitration clause. Okay, then it's fine, they are competent. If you appeal a decision of a federation, you have to show the CAS that there is an arbitration clause, and this is normally in the statutes or the regulation, or if you participate at the Olympic Games in the entrance form or in the World Championship, you as an athlete have to sign the entrance form, and normally there they put also the arbitration clause. You see, it's not by free will, but you end up in court of arbitration for sport. So then, for example, I give you an example of the Olympic Charter. Paragraph 61 of the Olympic Charter says, the decision of the IOC are final. Any dispute relating to their application or interpretation can be brought to the Court of Arbitration for Sport. And second, the second one is very important. Any dispute arising on the occasion or in connection with the Olympic Games shall be submitted exclusively. Exclusively. No state court can be approached to the Court of Arbitration for Sport. So that is the reason why every international federation that participates at the Olympic Games, they also have CAS. That is the main reason. Now, what are the natures of arbitration in sport? Normally, it can be disciplinary, so like doping cases, bans, or a sanction of a player to be banned for 5 games, 7 games in football, or fines. That is something you can appeal to CAS. And also non-disciplinary cases. For example, in football, FIFA gives the opportunity to a player and a club to go to FIFA internal instances. In FIFA, it is called the FIFA Dispute Resolution Chamber, which is not an arbitration panel in the sense of here. But they are deciding all cases in employment-related disputes between players and clubs, for example. And this final decision of FIFA, you can appeal to the Court of Arbitration for Sport. And to tell you, these are the most cases of CAS. Most cases are coming from FIFA. More than 300 per year coming from FIFA cases and disputes between players and clubs. Now, if you go to ordinary arbitration, I think I don't have to tell you this. It's like in normal arbitration. You can have a look at it later on. It's normal, you make the application, it will give a hearing, evidentiary proceeding, and so on. But what is important is in the Court of Arbitration is the appeal procedure. Now you have in front of you a decision of the Court of Arbitration for Sport, and from FIFA, for example, and then you can bring a statement of appeal to CAS. And you have to name the parties, and you have to say why they are competent, and so on. And then the deadline is normally 21 days, but in the statutes of the federation, there can be another deadline. For example, UEFA, against disciplinary cases, you have to appeal within 10 days. So you have to be careful that you not only look at the CAS code, but also at the statutes of the federation to be in time. Then, if you have filed a statement of claim, then you have to file 10 days later the fully motivated appeal brief. And be careful, you have no second chance. Everything you want to claim must be in this first application. Then the other side will be heard as well, of course, and they also have to put in place everything in their first application. Then you see that is the reason why only if the counterparty agrees or the arbitrators you can supplement with new facts. New law you can always bring. New law arguments, it's always possible, but new facts are not possible always. Now, a CAS panel, what can they do? They have in front of them a decision of FIFA or IOC. They have full power of review. They can annul the decision. They can send back the decision for new decision. They can make a new decision. And they put themselves in the shoes of the, let's say, FIFA or IOC, and they make a full decision. And that is what they can do. There will be a hearing normally. Is it public? It was never public up to the moment that Claudia Pechstein did sue Switzerland in front of the Court of Human Rights, and she achieved the right that you can have a public hearing also in front of CAS, but only in cases where a forced arbitration is given. So not in normal commercial arbitration where CAS is the first instance, is normal arbitration, then you don't have such a right. But in sport arbitration, yes. So that is a little bit what the hearing has to do there. And then what is important, which law is applicable in CAS. And if you read this slide, you will see that it is not very clear what kind of law will apply. So they put in place the applicable regulations, then the law chosen by the parties, then the law of the country where the federation is. That is normally Switzerland. So Swiss law will play always around. And you see, and then rules of the law that the panel deems appropriate. So that makes it totally unforeseeable what law they will apply. That is something which is very difficult to predict. Then the award will be done by the majority as in normal arbitration. What is interesting, no dissenting opinion is allowed. I don't know why, but it is like that. And what is not so good, not all awards of CAS are published as of now, which means you can be confronted with a counterpart that has access to unpublished decisions, which can come to a surprise to you. And that is the reason why it would be very important to publish every sports decision of CAS, which is actually not yet the case. Then you can also request provisional measure in front of CAS. For example, if a national federation has banned a player for doping for 2 years, so you could try to appeal this decision, and in the same application you can ask that for the period of the proceeding, the suspension shall be lifted. That is possible, but you have to really motivate it very well, because it's not so easy to get it. You have to show that there is a risk of irreparable damage. You have to show that your case has good chances, and then you must show that the interests of your client prevail from the interests of the federation. Now we come to, if you have a final decision of CAS, what can you do? As I told you, you can appeal such a decision to the Swiss Federal Supreme Court, but it is very, very, very difficult. That is one possibility. And you can also ask for a revision of the arbitral award with the Swiss Federal Supreme Court. For example, if you have proof that somebody has done criminal acts, and that is the reason why you have lost the case, you can try to do a revision. That must be done within a certain period of time, normally 60 or 90 days. Now, we have here the appeal procedure in the Swiss Federal Supreme Court. The Swiss Federal Supreme Court is the appeal instance. Then what is very important, the Swiss Federal Supreme Court, you have to tell them, it's the highest court in Switzerland, but you have to explain them the law. It is not enough to say, I think they have violated this. No, you have to tell them, they have violated this because of that, and that is the law. The law is like that, and it's a very difficult procedure, the most complicated procedure you can imagine. You can also ask the Swiss Federal Supreme Court for provisional measures. I have done so in the case of Claudia Pechstein. She was banned by CAS for 2 years, and Olympic Games were out of the, were coming in the next few months. And we could obtain a suspensive effect with the Swiss Federal Supreme Court, and the Swiss Federal Supreme Court allowed her to participate at qualification tournaments for the Olympic Games. Because this is something, if we would have won in the Swiss Federal Supreme Court and she would not have been able to participate at the qualification games, that is an irreparable harm. You cannot cure that with money. Only with money you cannot give the access to the Olympic Games later on. That is, it must be such a case. Another case where the Swiss Federal Supreme Court gave also the possibility for provisional measure was the Guerrero case at the FIFA World Cup. He was also banned, and then it could be achieved that the ban is lifted. Now, the Swiss Federal Supreme Court is bound by all facts CAS has decided. You cannot bring any new facts there. And the costs are quite high. Now, what are the appeal grounds? Only 5 grounds. And these are exclusive grounds. No other ground is possible. So you can see the limitation. Wrongful appointment of the arbitral tribunal. Well, that's an easy one, but normally it does not happen. Incorrect decision on jurisdiction. That is the best one, because there the Swiss Federal Supreme Court has free discretion to look at everything. Here, the third point, if the CAS has decided ultra, extra, or citra petita, then you can also appeal. Or the breach of the principle of equal treatment of the parties, or the right to be heard in the procedure in front of CAS, or the breach of ordre public, which is a very, very difficult one. That the ordre public is looked from the Swiss Federal Supreme Court as something that it's not only, it is not enough that it violates Swiss mandatory law. No, it must be well accepted all over the world principle, you know? So it's very, very difficult. Then you have to know that since the existence of CAS in 83 up to now, not more than 15 cases were successful in the Supreme Court. So you can see something is perhaps wrong. It's too difficult to overturn a cost decision, I would say, because I don't say they were bad, but it is not normal that only 15 cases are bad. It's not possible. And I could win one in 2018, a player, Matthias Kelotto, against his agent. You can read this later on. It was about jurisdiction. As I told you, jurisdiction is the less strict one of all the 5. If you have to choose one, take this one. Then what can you do against the decision of the Swiss Federal Supreme Court? You can appeal a decision of the Swiss Federal Supreme Court to the Court of Human Rights. And more people, as you know, only 15 cases could be won in front of the Swiss Federal Supreme Court. And you can imagine that a lot of athletes are not happy with that. And they try to find other ways. And in the last year, Adrian Mutu tried to sue Switzerland. Claudia Pechstein, where I represented her in the Swiss Federal Supreme Court, where we brought up the right for a public hearing, but it was dismissed. But then in the Court of Human Rights, the Court of Human Rights decided Article 6, which normally is not directly applicable in arbitration cases, is applicable in sport arbitration cases. And why? Because it's forced arbitration, whereas commercial arbitration is not a forced arbitration, and you can renounce on the rights of the Convention on Human Rights. That is the difference. And I could win also a case in front of the Court of Human Rights 2 months ago against Turkey, where they decided that the internal football system was not okay. They were not independent because they had a system where you, as a player, had to go to the internal arbitration body of the Turkish Federation. But the Turkish Federation, they decided everything as in the beginning IOC. They decided who is the arbitrator, and the player could do nothing. They were all from clubs. So, and they decided now that this is not okay. And I think that's all I can tell you. If you have questions, I'm here. Hello.
Hello, Mr. Rosie Meloni.
Ask a question. Can kindly raise just post that in the chat box. You may raise your hand. I'll unmute you all, and or you can post the question in the chat box.
Thank you, Dr. Meloni. That was a great presentation, very insightful. And we have some instructions for the participants. If you have any questions in particular, you may post it in the chat box, and we will address it to the speakers at the end of the session. Thank you. So yeah, we have our next speaker. He is trying to share his window. So we have with us Dr. Xiong. Dr. Xiong is the founder and president of International Law and Technology Interoperability Association. He works as a consultant at United Nations office at Geneva. He's also the founder of China Index, which is an independent research project to promote the understanding between China and the rest of the world. Welcome, Dr. Xiong. Please take over.
Thank you. It's my honor to be invited and to join with colleagues from India, and thank you. Special thanks to Dr. Saravana. It is my honor. So today I'm going to discuss about a case study that recently when the judgment has been made, which was in March. It was regarding a very famous Chinese swimmers regarding the violations of anti-doping. So during this presentation, I wish like we can have some exchanges, you know, so we can have some ideas of exchanges of how do you think about these cases, and what do you think like these cases can bring to your legal professions in the future, and what can contribute, and what do you think what you can do in the let's say in the international environment. So this is the arbitral reward regarding the case. So it was made public on the 1st of March. So begin telling these cases, I would like first to introduce a little bit about what World Anti-Doping Agency, the WADA. World Anti-Doping Agency is foundations and has 80 members from the government and 80 members from Olympic movement, respectively. And it is an independent international anti-doping agency constituted as a private law foundation under the Swiss Civil Code, Article 60 to Article 70, around that part. And WADA has its registered seats in Lausanne, Switzerland, and its headquarters is in Montreal, in Canada. So the aim of WADA is to promote the coordinate and the fight against doping and sports internationally. And so regarding the authorities of WADA, as it was related to the Article 23.11 WADA Code. The WADA Code signatories encompasses a wide variety of major events organizers, such as WADA, International Olympic Committee, IPC, National Olympic Committees, National Paralympic Committees, and National Anti-Doping Agencies also. So, on the other hand, the players are not signatories to WADA Code, but whenever they enter into competitions, they are committed to respecting and complying with those rules governing the anti-doping, although they are not direct signatories. So here I got a question you're from the Indian colleagues, like say, how does the National Anti-Doping Agency in India incorporate its rules with WADA? You know, so WADA, they has a lot of the signatories agencies globally. They have China, which is called CNICA, and the Indian, this is the NADA, or say. So is there any colleagues could share a little bit experience on this? I say, how about Dr. Sarvanan? Do you have some ideas on the how is the national in NADA incorporated with WADA?
Tian, sir, sorry, I have no idea on it. Please explain.
Okay, I don't have any idea. I mean, I'm not familiar with the Indian NADA, so that's why I posed this question, and I hope if you can share some idea, that would be great to exchange this. So regarding the athlete part, so the athletes, they have this kind of reporting system for WADA. So you can see this is a graph which is this is a chart that for the professional athletes, they need to report 1 hour every day, that they must report that there will be availability of 1 hour per day per slot, that they can have the anti-doping check by the anti-doping officers, like from the in this case it will be IDTM. So you can see from this chart. So this box is like you have to report where you are there, where you have to, like say, as I made this a little bit more bigger. It's like, look at this. So you have to see in that particular time where you are, and when you are free to have a check. You have to give 1 day, a 1 hour slot per day, and you have to be reported like not within, like, I don't know how many hours, it's around 12 hours before, around that. So So my question is, do you think this is really good for the athletes? I mean, what I'm saying is, do you think it's kind of inconvenient violation of their privacy rights? I mean, this is also a very interesting question. I mean, I don't know whether any colleagues would like to also discuss a little bit on this perspective.
I think
yeah.
it does violate privacy to an extent, but it's kind of comsi comsa, you know. It's yes and no.
Yeah.
But certain aspects,
in which perspective is yes? In which perspective is no? And how do you think?
Yeah, it does violate privacy, sure.
Yeah, great. I mean, I mean, on the other side, people saying like you are athletes, right? You perform professionally athletes, so you have to respect these the regulations. Although the athletes are not very involving in this, making this regulations. I mean, that is in some perspective. Although what are they comprise of some athletes, but that's this like saying it's more from one side. This is a as you said, it could be a violation of the privacy rights. So when it comes to the Sun Yang's case, what makes it so special? Why it is not don't have the why it is not only going to be discussed by the Chinese lawyers, but also I would like to share with colleagues from here from India, because what I think is this case is remarkable because it shows only one side is how Chinese lawyers need to be better connected with the Western parts, especially particularly on some on this sports arbitration. I hope through these cases, I mean, it can provide you some ideas that in your future legal professionals, how you can better connect it with the Swiss colleagues to so basically these cases involved with FINA, which is the World International Swimming Federations, which authorized IDTM, International Doping Management, a company. It is a service providers. They have 3 people when they doing what I said here. When they doing this kind of 1 hour, this kind of check of the athletes, they usually comprise with 3 people, 3 colleagues. One is called the DCO, the Doping Control Officer, and BCA, Blood Control Assistant, DCA, Doping Control Assistant. So they, so these 3 people together, they're gonna to, of course, they have different duties. But the priority thing is they got to collect the athletes' urines and take that urines back to the laboratory for the check, of course. And that at that day, so in this case, the athlete, Sun Yang, said that okay, he is free during the 10 p.m. to 11 p.m. at that day, and the doping control officers came, and then the athletes signed the doping control form, and then he collaborated and providing 2 blood samples to the and also provide the urine samples to the both blood control assistant and the doping control assistant. The problem is that when they're doing this kind of this collection, that the athletes is so famous in China. He's the I forget he's the Olympic record keeping of the swimming of the 400 meters and also he has won more than 5 Olympic gold medals. So he's so famous, and you can see his advertisements are all over the street in China, even in the bus. So So what they did is like, so the doping control assistant, as claimed by the athlete, in this case, when the athlete claimed that the DCA, the doping control assistant, take the photo of him when he was urinating, which is a very interesting fact. Of course, there was they need the proof to support it. As I see, I don't see. They claim they had a video. They didn't make it public, and then the athletes found it was something wrong. So the athletes checking the credentials of these people, the DCA, BCA, and DCA. There are some scratches there. How does it work? It's very interesting. I don't think I did made it. And then the DCA and BCA. What the problem in this case is like the both DCA and BCA don't have enough individual authorization letter from either FINA or IDTM. Okay, so it's not on my. How is this here in my screen? That's fun. So the athlete assisted. So found that the athlete said that they assisted a security guard. I mean, before they doing this, the athlete and the ask those take all the evidence from DCA and BCA and said like, look, you don't have the credentials, you don't have the forms that prove who you are, because what they did have was two things at that time. One they have is the DCO. I forgot to mention the doping control officer. They have she has the authorization letters, but these other two doesn't.
I think he has some issues with his connection. I think he has some issues with his connection.
Yeah, we'll wait for some time. We'll wait for a few minutes. I think he should be back within a minute or so.
Maybe he's just trying to reconnect.
He's coming in. He's coming in.
Okay. Can
Wait for a couple more minutes just to see if Dr. Shang is able to reconnect with us today.
Ashita is reconnecting.
Yes.
He's reconnecting?
Yes, he should be back in another 20 seconds.
Okay. Yeah, I think he's back.
Yes.
Corona.
Hello, Dr. Shah. Are you able to hear us?
Yeah, yes, I'm able.
This voice is breaking up. I get that.
Okay. Hello?
Hello, Dr.
Hello?
Shah? Dr. Shah, are you able to hear us? We can wait for a few more minutes just to see if he's able to reconnect with us today. In the meantime, if anyone
One second, Harshita, 1 second. He says that he is able to hear us, but unfortunately, I think now he's coming up.
I can't hear him.
Now he is on screen at least. Yeah, he's also seen moving on the screen.
Yeah. Dr. Shah, can you hear me?
Okay, he is trying to switch off his Wi-Fi and switch it on, the traditional method. Just give him some time. Okay.
Yeah.
Arshita, in the meanwhile, if you have any questions, you can ask Mr. Dr. Valoni.
Yeah, sure. We have a couple of questions noted down here. So how does the athletes generally and what perspective do they have on sports arbitration, Dr. Valmi? Your thoughts, please.
What kind of chances or ideas, or whether they what they think about it? Yeah.
They think about it. That's correct.
Yes. Well, it's as I told you, it's a little bit problematic because they are forced to accept. There is no choice. So it's difficult for them to say we totally agree. But what can be said is the rights should be stronger. I think what we have in Switzerland is appeal to the Swiss Federal Supreme Court with these 5 grounds, which are very, very restrictive. I think in sport arbitration, we should have a possibility to have less severe restrictions to go to the Swiss Federal Supreme Court, because you as an athlete, you are forced to renounce on the state court. And you have to go there, and the protection must be similar as in a state court. And actually, it is not really the same. Huh? It's not comparable. Especially in state court, you can get real legal aid. That means you can go with your lawyer, and your lawyer is paid by the state. Well, I don't know in India, but in Switzerland and in Europe, we have this system that you have to pay no costs for the proceeding if you don't have enough money. The problem in sports arbitration is it can be very, very costly. And okay, they have introduced a kind of legal aid, but first of all, you have to change the lawyer, because the CAS does not pay you. They don't pay you. You have to choose a pro bono lawyer from the list of CAS. And it's not so good that you have to change lawyer in the middle of the procedure. It is absolutely a catastrophe. It takes too much time, and it's not so good. So I think this must be changed, and also how the panel is composed shall be changed, because the General Secretary of CAS has a lot of power. He puts the man in the middle. The appeals president of CAS, he puts you as a lawyer or an athlete, you choose your arbitrator, the other side chooses the arbitrator, and the one in the middle is chosen by the appeals panel president. And you can imagine that theoretically, I don't know that it happens, but you could theoretically choose the one certain way, you know, he's more critical, he's more formalistic, you see, and I think it should not be like that. It should be a random system or a neutral standing panel. I would be for that. I always think that it should be improved. It's good, the system, but it can be improved.
Sure, thank you. So our next question to you is there a specific time frame that is set by CAS for settlement of a sports dispute?
Settlement of disputes. Well, normally they don't ask you whether you want to settle, but in sport arbitration, the free will of the party is decisive. That means the parties are in control of the litigation. That means if the parties want to settle, they can settle, and CAS has to accept it. So it is possible at any time to settle, of course, before a decision is taken. But I remember a case where we represented I represented a Italian player, two Italian players. They after the game there was a doping control, but they lost the game, and the president of the team came and told every player, come into the locker room immediately, and they locked the door, and he was shouting at the players because they lost the game. It was an important game, and the doping control officer was in front of the door, but they did not let him in, and this ended up in a 2-year suspension for the player. And then this was a scandal, this decision. And what happened, even after the CAS decision, all parties, including WADA, agreed that it was reversed. And you see, the power of the party is there, but you need the counterparty to agree.
Well, so what are the common disputes that are taken in sports arbitration?
I did not hear that well.
What kinds of disputes are commonly taken in for sports arbitration? The nature of disputes.
Yeah. The nature of the dispute is it can be different. Well, it can be contractual disputes out of an sponsoring agreement when there is an arbitration clause. It can, but most of the cases are employment law disputes between players and clubs, or disciplinary sanctions. For example, UEFA, with this financial fair play system they have in place, they sometimes impose sanctions on clubs, as they have done against Milan or against Manchester City. And these decisions can be appealed to CAS, for example. And every WADA, every WADA decision can be appealed to CAS.
Excuse me.
Sorry, I have to. Carlos, could you? I don't know why it is saying it hasn't worked, and my phone and my computer, the internet is safe, it's all stable. Sincerely apologize. And I think I was I stopped at the time that, so we don't have the screen now. So let's have more fun.
I think we still connection.
Glass container and took the blood vessel out. And the ambulance also poured the doping control. The both BCA and the BCA has signed that they acknowledge that they don't have the accreditation. What the athletes do. So what happened is that it's clear that this case in then the water anti-doping agency happening on the March 2019. And in November 2019, there was a public hearing taking place, and on the February 20, there was an award. They say it's a award. So as soon as possible, so there will be two pages more. So here's a question. As to what you think the chance of the could be justified or could not be justified. But I'm asking whether it's by the ECHR and the role of a lot of other work. Is there a good answer?
Carlos, so
Or not?
Sean using
Mr. Carlos, the audio
Yes.
of Ian's is not clear, and we are not able to get anything that he is trying to inform us. It is jarring and it's completely not audible. Can we do anything about it?
You actually, Mr. John is using my phones to deliver his speaking as his presentation. So can you all hear his voice?
No, we are not able to hear his voice in clarity.
听着你继续吧，我 try to 我尽量放大一点吧。
Okay, I think Dr. Shonk is having trouble signing in. So maybe we could have Dr. Shonk present his case study on anti-doping another time. We could schedule another time and circulate the invitation.
Yes,
So if the participants have any other questions, you can post it on the chat box.
yeah, we have a question. We have a question from Ms. Richa Pachuri. to Mr. Valloni. The question is like this. What are your thoughts on the lack of legislation and legislative regulation, especially in India, with regard to sports? Is the current system detached from the state, focusing the respective sports federation for the governance and regulation? Governance and regulation, especially in India, with regard to sports, is the current system detached from this state, focusing the respective sports federation for the governance and, I think it's been repeated. What are your thoughts on WADA's decision to ban Russia from participating in the Olympics? So basically her question seems to be, is there enough regulation with respect to the sports in India? And your thoughts on the ban on Russia from the Olympics?
Yeah, okay. Concerning India, I really do not know the actual regulations, the national regulations in India. But what I can tell you, what would be best, and this is not only for India, but it's for every state. I think all the national federations in India in sports, they should sit together and they should try to establish an arbitration, a sport arbitration court in India, where you can appeal every decision from an Indian sport federation to this national Indian sport federation arbitration body. And then you can also think that this decision of this national Indian sport arbitration body could be appealed to CAS, for example. So that is a system that I also helped Georgia to establish, because it makes sense. Because if every federation tries to put up an arbitration panel by themselves, it is too costly, it is not effective, it is not harmonized. So I think the best is to establish something national in India in arbitration, if this is possible according to Indian law. As you know, in Switzerland, everything is arbitrable unless family cases, but if it is about money or disciplinary things, it's no problem. I don't know in India the law in arbitration, but I assume it's possible. Yeah. And to the second case, Russia, there I have given different interviews to Russian TV already in these cases. And I must say, I also represented the Russian Paralympic Committee. And I must say, I was very, very not satisfied, let's say like that, about what is WADA. Because WADA, they have made a report, Mr. McLaren has made a report, and if I remember this case, there were a lot of allegations they made against athletes without mentioning who made the allegation. So you can imagine, how can you defend yourself if you do not know who was saying what against you? And I think this is not the way you should treat athletes. And what I do not like is also to ban collectively all athletes. Because if you ban Russia, you ban all athletes in the end. You do not hurt Russia. Putin is not competing. it's not a problem for him. But we we represented in front of CAS all the disabled athletes. They all trained for 4 years to be able to participate in Rio de Janeiro. And nobody of all these athletes that were qualified and were on the list to be participating at these games were accused to have committed a doping offense. Nobody of this. Nevertheless, all were banned. And you see, I think this is a collective punishment which is not acceptable. And I tried to appeal this decision of CAS, which was a catastrophe, also to the Swiss Federal Supreme Court, but not successfully. But I'm still of the opinion it was totally wrong. And that's the reason why I'm not so in favor of collective bans. And I think if somebody has committed a doping crime, yes, he must be banned. But nobody else. That is not okay.
Fine.
Thank you, Dr. Wong.
Actually, there's another question from Manadi asking what is the CAS position status? He wants an elaboration on that.
CAS position on what?
The question says just position. I think how it has been working, can you elaborate? I think you have already done it in your speech itself.
Yeah, CAS is there. It's quite a good system, but I told you it can be very much improved. First of all decisions must be published for transparency reason. Then the composition of the panel must be new structured, that you can be sure that there is no influence, which is, I don't say there is, but it should not be possible also that there is an influence. And of course, if we talk about the arbitrators, there are 393 arbitrators. This is a closed list. I don't think that it is necessary to have a closed list, first of all. Why? A party should be free to use the arbitrator he wants, okay? He can now choose from 393, but we have to know who puts the person on the list. For example, we in football, I'm in the board of the World Players Union, we can put on this list exactly the amount of 20 arbitrators. So 20 arbitrators of 390 are put there by the athletes. That is not enough. That is not enough. That is what I can say.
There's one more question from Mr. Saravana Ganesh. What is your thought on the ban imposed on Manchester City by the UEFA club, financial control body, and the appeal of that club? And what are the norms that appellant should follow?
Well, this decision is not final. That's the first comment. It's UEFA who made this decision. Of course, we have to be careful with these decisions of UEFA. Sometimes they want to make an example and to state an example on certain issues, also on big clubs, to show that they are severe. But sometimes they know that their decision will not stand in front of CAS. So I think the ban that was published was probably too severe, and it will be reduced in the Court of Arbitration for sport by half, I would imagine. And this based on proportionality, because proportionality is something you can always invoke. Every decision must be proportional. That is very fundamental principle.
Okay. Mr. Saravanan has a question for you. What is the scope of young lawyers in sports arbitration practice?
The scope of young lawyers?
Yes.
Well, I was also a young lawyer when I started. You have to start somewhere. And I think arbitration is an interesting field, and sport arbitration even more. It is very specific, and you can combine, if you love sport, a little bit your hobby with your profession, and that is the best you can do. So I think it is a good choice to try to become a sport lawyer, but it is not so easy because it's quite trendy, and the amount of cases are limited, of course. Commercial arbitration, there are much more cases than sport arbitration. That is, so it's difficult to only live from sport arbitration, I would say, totally.
Okay. Mr. Carlos is trying to get Mr. Tian's, Dr. Tian's online. So we'll give it another option
You start.
to hear Mr. Tian's.
You start. Tenza.
Yeah, please start.
Tenza, you try it.
Is he already talking from us? Sorry, we are unable to hear him.
Sorry, Mr. Carlos, we are not able to hear
I would
anything.
like you to discover this. And second is the reform of the
Can you hear that?
for sports.
It
Tenza,
is
can
jarring.
you
It is jarring.
speak up?
There's no clarity in it. There's a lot of noise.
That's how that whether people agree with the idea.
Mr. Carlos, maybe we can ask Mr.
But
to have
analysis regarding the
session on
cast. We have in the cast, have more. Should have more Asian lawyers or have more black people to involved in that as well. And third one is about the strategy about the public hearing. So this is I wish you like to compare with this case to the Michelle Smith cases, which back in the 1998 and in the past hearing that regarding she was also a swimmer and gold medal winner. So yes. And thank you very much for making the connections. And yes, and you are more than welcome to visit in China or in Geneva. If you come anytime to Geneva, let me know. I'm sorry for that. And thank you.
Finish.
Oh, thank you. Okay, fine. We'll have it again. That part of the session we'll have again, Mr. Tian's session again. Okay. Over to you, Hashita.
Yeah, thank you, Dr. Velny. Thank you very much for joining us today. It was so unfortunate that Dr. Zhang was unable to present his anti-doping case, but we would try to schedule it another time, and we'll still try to circulate the invite for that too. I'm very delighted to have you all in today's session, and thank you very much for joining us today. Thank you, Dr. Velny and Dr. Zhang. Both of you presented so well, but unfortunately, Dr. Zhang split off. The content was very informative, fascinating, and timely, of course. I hope our participants have found it useful too. So our next session is on entertainment and media arbitration, which is scheduled on the 8th of May. So the speaker is attorney Mr. CNICA Jayadeva. He's from Sri Lanka. So we will be circulating the invite sooner for that. So please pre-register on the link that's going to be on the invite. Meanwhile, hope you all continue to stay healthy and well in the coming days. Thank you very much, and we'll see you in the next session. Thanks a lot.
Thank you.
Thank you so much. Thank you, Mr. Valoni. Thank you.
Thank you.
Thank you.
Thank you. Thank you.
Thank you.
Thank you.
Thank you one and all to the participants.
They